WOCA.
Ocala.
All right, 25 minutes before 10 o'clock, beautiful Friday morning, and it's time now for Ocala Magazine Radio. Your host is John Sotomayor, ready to begin today's very interesting show. Good morning, John.
Good morning, Larry. How are you today?
Pretty good. Pretty
Great.
good. Got a good show in store, huh?
Yes, we do. Stand Your Ground is back in the news again. It was reported on Saturday, February 23rd, that the state task force appointed by Governor Rick Scott had provided their findings, and this is in time for the next session that meets in March. They report that the law works and should not be overturned. Also, earlier this week, on February 26th, marked the one-year anniversary of the death of Trayvon Martin at the hands of neighborhood watchman George Zimmerman, and that case brought the law into the national spotlight. So to help us understand what this means to the community, and particularly to the case, I invited two guests to share their views on the topic. With me today is Representative Dennis Baxley, the originator of the law. Good morning, Dennis.
Thank you. Good to be with you, John.
Good morning. And Mike Sizemore, retired railroad official and former candidate for county commissioner. Good morning, Mike.
Good morning, John. Pleasure to be here.
Great. First, I'd like Representative Dennis Baxley, if you would first give us a little background on Stand Your Ground. What does it do, and what inspired you to create it?
Yes, when I was in the legislature back in 2005, we'd just gone through a number of hurricanes, and we had a lot of property in disarray. We had a number of individuals living on their property in RVs to protect their property and try to rebuild it. And in that atmosphere, we had a case out in the Panhandle. Dr. Peden, Senator Peden at that time, brought to my attention where a gentleman had, he and his wife, been in an RV protecting their property there, and an individual broke in during the night into the RV, and he shot and killed this man. It was a number of months before he knew if he would be charged with something for doing something wrong. And Dr. Peden and I just agreed that that shouldn't be that way in Florida, that citizens, law-abiding citizens, should know that we had canonized in the statute that we would stand beside them if someone advanced against them and they were in harm's way. And so the Castle Doctrine has been around for years as common law. It was never in a statute. Also, in the prosecutorial world, there was this concept of duty to retreat that had developed and evaluate whether someone could have done something different or gotten away or left, retreated instead. Mm-hmm. And but it was purely in the purview of prosecutors to decide where they want to go with it. So we wanted to clarify, so we adopted in 2005 this bill, self-protection bill, that would indicate that if you're in your home or if you're in your vehicle or anywhere you have a right to be, you shouldn't lose that right of self-protection just because you're in a parking garage or on a walking trail. But if you were a law-abiding citizen who's doing nothing wrong and you came under attack, that you could meet force with force, including deadly force if necessary, and stop that violence, and you would be immune from prosecution of doing anything wrong when you were actually doing something right, which was to stop a violent act. So that's that was not controversial in the legislature. The Senate passed that bill in 2005 unanimous, and we only had about 19 people vote against it in the House of 120 members. It's always been controversial in the media because the whole concept of self-protection and empowering people to stand their ground in the face of an attack seemed somehow aggressive or assertive.
Okay, understood. And back in July 2012, we covered this issue in our magazine. Back then, you participated in that story with me. You gave some examples of where you intended for the defense to be used in the interest to protect the victims. Could you tell us again some of those examples that you used then?
Well, clearly, the most serious to me are young women who are under violent attack. No one should be beaten or raped or murdered, and wonder if they defended themselves, if they were going to be in trouble for taking some action or armed. Particularly, I think of young women who have the ex-boyfriend that outweighs them double, and he's already sworn, I'm going to kill you, and if I can't have you, nobody is, and they live under that atmosphere, and so I think they need to be empowered. The only way to equalize a situation like that is to be armed, and we want to know that our law-abiding citizens do have that object of knowing that the state is going to stand beside them if they're acting in that way.
Absolutely. And you also mentioned two other examples, the elderly and people who may be physically weaker. Is that correct?
That's right. We had a situation here in Silver Spring Shores with a gentleman in a wheelchair at home. He had to use deadly force for attackers that came in to attack his home. And then we have a lot of people that live in areas where there's a lot of drug activity and gang activity that they're subject to home invasions, and that's the only way an elderly person can really equalize the situation. So those are the kind of people that I think about when I think about why we passed this statute. And sure, there's going to be some difficult applications. It's wherever you put the foul line, is it in or is it out? There's going to be some tough calls and some very heartbreaking situations. No one wants to see needless deaths.
Right. Thank you, Representative Baxley. Mike, is this how you understand the law to be? If not, what's different?
Well, first of all, let me say everyone should want to feel safe and secure in their homes. There's certainly no question about that. And those who are unable to defend themselves certainly have the right to do that, and if a weapon's involved and they use that to make them secure, Second Amendment allows for that. I don't think anyone would disagree. The reasoning behind bringing the law to being, as Representative Baxley just pointed out, there's a lot more to the story. It goes much deeper than that. I've read that report, and it, without getting into that detail, it wasn't just simply the guy broke into the house. It was a long story. The guy was from South Carolina, and the story goes on. It was very unfortunate, very tragic, and very emotional for the people involved, I'm sure. But getting to where we're at today, there's just huge numbers of people who are questioning how this law is affecting us as a society.
Yes.
The most significant one was the Tampa Tribune report, and everybody knows about and reads. We have example after example where the term presumption, whether or not the person just presumes that they're at threat, or they have that threat of losing their life. So there's lots of recommendations that is even from the task force that is offered by the vice chairman of the task force.
Yes.
In the report, and he endorses the report of the state attorney, who Rundle, who writes. So I think there's a lot of need to look at this. Let's get it right.
Right.
Some changes and some tweaks I think are certainly needed.
Okay, let's take a look at the task force. Representative Baxley, what are your thoughts about the findings that they presented?
Well, I think first thing to remind ourselves of is this task force is a task force to review citizen safety and protection. It's not a kangaroo court to judge stand your ground case or to resolve the Trayvon Martin Zimmerman case, which is in fact still not come to trial. And so I think projecting a lot of other things into this, obviously that case brought the subject of self-protection to a high level. I was told, this gentleman can't be charged because of your bill or your statute that the legislature's passed. And I said, that's absolutely not so, because there's nothing in that statute that authorizes you to pursue, confront, or provoke other people. And if that's what happens, then you're on your own. That doesn't mean there isn't some other self-defense argument you may be able to make, that it was your life or theirs in the moment. That may have to be made. But in fact, what we found is over 70% of people indicate that they are pleased with this piece of legislation. They do feel safer and better protected by it, and don't want us doing anything to minimize it or deplete its effectiveness in terms of their protection. I think a wonderful thing that has come out of the task force too is a complete review of the whole situation and a lot more understanding about what the law is and what the law is not. And I think the underlying issue is not with the policy that's in the statute, but in how it gets applied. And I think getting some consistency and some things adjusted there, and that happens over time as it works out through judiciary process and procedures, and also law enforcement training and crime watch unit training. Those are all things that will improve the application, and those are things that are mentioned in the recommendations as well. But I think the general consensus was that it is a good law, that it is favorable for us to stand beside, that a reasonable person can review the facts, and if it's just not reasonable, then they're going to be arrested.
Yes, thank you, Dennis. Mike, what are your thoughts about the findings?
Yeah, well, there's lots of reports out there that anyone can go and read to prove that there's a lot of confusion. The representative's right. There is a lot of confusion out there about how to prosecute this law and the individuals that are claiming protection under it. For example, the First District Court of Appeals and the Second District Court of Appeals have ruled in opposite directions on the immunity. So the courts are saying that there's confusion. Prosecutors are saying that they want more clarity.
Right.
Police officers are saying they want more clarity. So without question, when you look at the report back in Tampa and you see the number of people out of 200 cases, that over 140 or 150 were unarmed and highly questionable about whether or not the individual was actually threatening their life or whether the individual was in retreat and running and shot. So something must be done to put more control. After all, as a society, we have dealt with conflict since the beginning of time.
Right.
And everyone should be interested in how we resolve that conflict without violence.
Absolutely.
So there's a lot of work to be done.
Okay. Thank you, Mike. So let's take a look at how this applied to the case that brought this to the forefront. That's the George Zimmerman case. Representative Baxley, you participated in my article, Stand Your Ground, back in July. Back then you said you didn't believe that the defense, as you intended it, did not extend to George Zimmerman. And as a reminder, you said because a self-defense case cannot be made when someone pursues or confronts people, as Zimmerman did, when he defied the direct order of the 9/11 dispatch not to follow Martin. Can you elaborate on this?
Well, again, I would underline that we need to let this case play out, and it's one of the reasons that I'm very cautious about what we do with this statute. Just because there's some problems with application and understanding the law doesn't mean it's bad policy. When you set policy, you try to look at what will provide the greatest safety and protection for your citizens of Florida and the people visiting our great state. And so I think in analyzing this case, we need to be patient. We're not going to hear all of it. A jury will, probably. And watch this case as it unfolds. But to start irrationally going around, reacting and changing a statutory law when we haven't even seen the outcome of the case that we're saying affected this and gives us cause to look at the statute, I think is premature. So that's my thing. I just don't want to be. I want to be in an atmosphere when we do policy that we're responding, but that we're not reacting. That we're not just providing a knee-jerk reaction, and then you go through a whole nother adjustment to what statutory changes you've made. And because you have some unclarity, it's not unusual that different courts rule against each other on issues. It goes along all the time, and that's why we have a review process. That's why we have a way that you can move all the way up through the court system to get final solutions. But I think as it plays out, there is more clarity developed, and I think this case if anything good can come out of it, it certainly raised our awareness of what this law is and is not. And I think that some of the misapplication, quite frankly, I'm puzzled by some of the rulings that I look at and how they arrived at that, giving what I see in the statute and how it would be applied. But I also realize there is a separation of powers. The legislature is to set policy, and the judiciary is to work out that application and apply the law. And then we evaluate, and we do go back every year, and we are looking at different proposals of things that may need to be considered. Another recommendation was to look at 1020 life and say, if you're giving a warning shot or you're showing a weapon to try to get the perpetrator to leave, which we know from the studies done with permit holders, that's usually what happens. Permit holders that hold a concealed weapons permit, they don't shoot people. They show their firearm and the perpetrators leave, and it decelerates the situation. And so I think as we look at it, we need to be careful about letting one case redefine how we're going to do public policy. But we need to be very vigilant of understanding the imperative of balancing self-protection with everyone's safety.
Right.
And we need to help educate the public, and I think that has come out of this case. More education also has been pulled back to hide on issues of race and saying, we have an ideal of equity before the law, but is it really working out that way every day? And I think that's the bigger question that was unveiled, is how do we deal with those kinds of inequities that do occur?
Thank you, Dennis. Mike, your thoughts on this?
Yeah, well, going forward is where we're talking about. What will happen from here on out. When you look at the recommendations offered by the task force, you'll find 10 recommendations. I don't see anywhere in the recommendations given by the task force suggesting that we address those issues that Representative Baxley just talked about. There's also another study, John, Senator Chris Smith issued this report. He gathered a task force together, and it was issued April of 2012. And there are some great recommendations in there. The very distinguished people compiled this task force. And the things that they bring out is that cases should be presented to a grand jury. We have a mechanism in place with the judicial process whereby the grand jury can assess whether or not you had intent, whether there was presumption. Settle those issues in the grand jury. That's where we've done this before.
Right.
I think the law enforcement people that I read, all the background I read from judges and law enforcement, is that there's not enough clarity in this law, and it's encouraging people to take lives when normally they would withdraw, back up, or not shoot. And the shot the shooting, a warning shot that Representative Baxley talks about, there's actually a bill being offered now in the legislature this term, H.R. 1047, and offered by Representative Cumby. He actually fired a shot, and he got involved in a dispute about whether or not that was legal or illegal. So he has brought forth this bill that if that happens, it's okay. You can fire that shot, and if you any outcome that happens from that shot, you're going to be held harmless.
Right.
There's a third-party issue here, John. That if a gun fire erupts and a third party is killed, they're held harmless.
Right.
So there's deep issues that we certainly can't get into here.
Right.
But I'm sure that everybody wants a good outcome.
Absolutely. There are a lot of sub-issues to discuss with this law. We're short on time, so we'll just focus on a couple other issues before we close. You mentioned misuse. Let's take a look at the black letter law, and it is printed in its entirety on page 21 of our July 2012 issue of Ocala magazine. Basically, in a nutshell, it allows someone the right not to have to retreat and can use deadly force if, one, they have a reasonable fear of imminent peril of great bodily harm to himself or another, and 2, who is attacked in the place where he or she has a right to be, that has not duty to retreat, and has the right to stand their ground and meet with deadly force. Representative Baxley, do you think there are any situations where this may be misused, if people feel that they can defend themselves anytime they wish?
Oh, there's no doubt. Anybody that's in a tight situation is going to try to use this statute for defense. But my point is, it's pretty clear that it would have to pass a reasonable man test that any reasonable person could look at it and see that you were in harm's way. If not, and these investigations go on, you don't have to be arrested at that moment. But my point is, if a law-abiding citizen is doing the right thing, don't treat them as a criminal. Put them on defense. Now, I mean, Senator Smith's proposal is that you treat them as a criminal and you make them go before a jury because they were doing the right thing, stopping a violent act. And so I think the facts are clear in the investigation. There's always an investigation in these incidents of law enforcement, and they make a decision about whether that's passes that test or not. If not, then they can be charged. But I don't think that we should automatically treat every person who has to act in self-defense as now the villain, as the perpetrator who has to defend themselves before a grand jury as if they did something wrong when they actually did something good. They stopped a violent act from occurring.
Okay. Mike, do you have a brief answer to that?
Well, I'll just briefly say that there's a lot of people who are now being not being prosecuted, who clearly but because of this law should have been prosecuted, and I don't think anybody would disagree with that. I trust the system. I think even the gentleman that Representative Baxley pointed to that caused this bill to come to fruition, he was excused from prosecution after the review by the grand jury. So the system worked then, and I think it works now.
Okay. I'd like to take a look at Section 776.041 of the Stand Your Ground law. It's the use of force by an aggressor, and this is the section that I thought was most interesting to the case of the George Zimmerman trial. Basically what it says is if someone was the initial aggressor and started the assault, but then backed down when the other person was attacking and wanted to end the fight, then he can still use deadly force against the other person. The facts of the Zimmerman trial are still under question, as you said, Mr. Baxley, but either way, whether George Zimmerman's fact case that he was attacked by Martin, or the contrary fact pattern that says by other witnesses that he was the aggressor and then Trayvon reacted to him and then Zimmerman reacted again, it would still fall into this policy. So my question is, what are your thoughts on this, about that particular statute and how it could be used?
Well, I would just say in all these circumstances, it's easy to be the Monday morning quarterback, an armchair about whether somebody could have or could not have retreated, or whether someone was in retreat or they just turned around and were circling you to come back and attack. It's a lot of armchair analysis, and when actually the victim of a perpetrator's act has seconds to decide if they want to live or die. Do they want to be raped or not? Do they want to stop this attacker or do they not? And there will be tough, close calls as to who's the aggressor and who's the victim, and that's the debate that you're having in this situation. What I heard in all the testimony on the task force is a tendency in the judiciary to just look at the moment at which this interaction is occurring. I think the bill truthfully contemplates a context for that event to occur.
Okay,
and I think that case will be resolved on whether truly this gentleman had abandoned any pursuit of observing Trayvon Martin and then he was simply attacked.
Thank you, Representative Baxley. We're down in the last few seconds of our show. To both men, what are your final thoughts? What's the last message you'd like to convey on Stand Your Ground? If you can each take 15 seconds. Starting with Mike.
Yeah, I certainly believe that the evidence is clear and the voices are loud and strong, that there's more work to be done on this law, and it needs to be done in this legislative session. We need to address these issues that are stopping the police from prosecuting.
Thank you. And Representative Baxley, last 15 seconds.
I would like just to use it to assure your listeners that as chair of the Judiciary Committee, I will do all in my power to make sure that we do everything to do anything to prevent your protection from being diminished.
Thank you very much. Thank you very much to both my guests, Representative Dennis Baxley and Mike Sizemore, for your contributions to this topic. Thank you, Larry.
Thank you. We'll be right back.